Welcome, everybody. My name is Jennifer from My TC Academy, and today we're going to be talking about title searches and title commitments. Now, here's the thing. Title searches and title commitments, they tend to be pretty long and can be a little bit confusing because there's so much information. However, the more you see them, the more you read them, you will learn a lot more. They're really not that difficult. It's just knowing where the information is. So before we actually look at a title commitment or title search, we're going to get into the ABCs of a title commitment. So let me show you what that is. Here's the ABCs of the title commitment. This is really going to help you guys understand the components of a title search and what each schedule stands for. So let's start at the top. So every buyer and seller, and let me make this bigger for everybody to see. So every buyer and seller knows that a title commitment is part of the process for purchasing or selling their home. Few have a clear understanding of what the actual commitment is. It is exactly that. It is a commitment from the title company to issue title insurance. Okay, title insurance, not home insurance, title insurance to a buyer or a lender if the conditions listed in the commitment are met. Below is a summary of each of the 4 key schedules found in a title commitment. Now, we're talking about the commitment, we're not talking about the schedule. And I just want to preface that because a lot of the times you'll get it's 2 different things, title commitment and title search, but oftentimes they send it as one PDF, one file. And it's just knowing where to find the information. When I first started off, I thought it was 2 completely separate documents. Some title companies may send it as like 2 separate things because maybe the title commitment is ready, right? They've plugged in all the information and the title search isn't produced until later on. So you may have 2 separate documents. But in reality, it's one document. All the information is on there. So we'll get into that. So Schedule A is where you're going to see the actual facts. That's where it's going to reflect the type of transaction we anticipate on insuring, as well as the current owner and legal description of the property found of record. The information contained on Schedule A should match the information set forth on the sales contract. So if the information is different, as a transaction coordinator, that's where you should be raising some questions. Sometimes there are instances where you have to remember, not everybody is used to real estate. And so sometimes there may be somebody in the family that has taken care of everything for maybe their grandparents or their parents. And, maybe they handle all their paperwork and they felt that they could sign the purchase contract. Number one, that's a huge no-no, low-key fraudulent. You can't do that because they don't own the property. They don't own it. However, you want to make sure that the information on Schedule A of the title commitment matches the purchase contract. Okay? Only the owner of the property should be signing. If it was a situation where the owner is incapacitated, maybe they have passed away or any of those things, then there needs to be a death certificate, some sort of power of attorney, some sort of probate that has been done. There needs to be documentation in place, right? This is also the job of the title company to make sure that they're staying on top of these things, but you are the additional set of eyes. Schedule B, buyer notification. So Section B or Schedule B says sets out the exceptions and exclusions from coverage found of record. Any persons or entities having an interest or right to use or restrict the use of property will appear in Schedule B. I'll read that again. Any person or entity having an interest or right to use or restrict the property will appear in Section B. Copies of the exemption documents referenced on the Schedule B will be provided to the buyer for review. So let's talk about the exclusion or exceptions part, right? So there may be certain transactions like a sub two where the title company is not going to insure, or they're not going to include the mortgage as part of it being covered, right, by their policy. That may be listed in this section in Schedule B. Now, talking about any persons or entities having interest or the right to use or restrict the use of the property. What are they actually talking about? Have you ever seen a property where, let's say, in order for the light company, okay, let's use this example. There are two houses and they each have a shared driveway. Well, that would need to be mentioned on here because the neighbor needs to have legal right to use that driveway because it's a shared driveway. You may see other things like a light company needing access or having the permission to walk through the yard in order to maybe do some maintenance on a light pole or something like that. So anything that gives access to somebody else other than the owner, it'll be in the paperwork. And I'm smiling because I'm thinking about all of the conflicts that neighbors tend to have or homeowners tend to have with maybe companies walking through their yard or a neighbor using part of the land, maybe because they need to get to their driveway, something of that sort, right? A lot of these issues would be resolved if people actually read this section. Maybe they forgot, maybe they didn't know. But yeah, I actually, as an agent, I went to a property which was the weirdest setup. It did not have a driveway, but it had a garage. You may be thinking, okay, it had a garage. You can just drive onto the grass and get into the garage. Well, no, the garage wasn't towards the front of the house. It was on the side of the house. And in order to get to the garage, you would have to walk through the neighbor's yard to get into the garage. It was the weirdest thing. It may have been an afterthought. I don't know. But those are things that would be included here, like where they need to access and things like that. Now, as a transaction coordinator, that is not your job. That is more the agent's role, right? If there's an agent involved, they should really be looking at that. The investor, the person that's purchasing this, they should really be looking into that. Because if you see something that has a weird setup, you may want to question it. Not you as the TC, but the buyer or the agent that's part of the transaction. We always have to remember our role as a TC. We're not giving legal advice. We are just educating our clients and assisting them with the communication. Schedule C, clear to close. When you hear those beautiful words, clear to close, you know there's going to be a date for that closing. Let's talk about this a little bit because sometimes people think that the date that's on the contract is a hard and set date. That is the day that we are closing. It's not until you get the clear to close from the title company. That is when the actual closing is going to happen. That means that everything has been met. And we're going to get into that, into the certain requirements that are needed in order to get that clear to close. So, clear to close sets out all matters found of the recorded of record affecting the title, which must be resolved by the seller prior to closing. This schedule also includes information regarding the area, the boundary, coverage, and T-9.1 endorsements. According to the sales contract, your owner's title policy will automatically include an area and boundary coverage and restrictions, encroachments, mineral coverage. Unless declined prior to closing, the area and boundary coverage survey deletion will be an additional cost of 5% of the owner's policy. A T19-1 endorsement will be an additional 10% of the premium. The T-19-1 endorsement is purchased with the area and boundary coverage, as mentioned above, and the cost of the T19-1 endorsement will be discounted by 5% of the premium. We're not going to get into all of those wordy things, okay, because that is really for title. But pretty much, there are certain things that may come up in the title search. Whatever comes up in the title search, let's say there was a lien, a mechanic's lien, the seller needs to resolve that prior to closing. We cannot close until that is clear. Now, as far as the other things, endorsements, encroachments, mineral coverage, like all of those things you guys don't have to worry about. Those are things that are provided by title. Certain properties are located on certain pieces of land where maybe they have mineral rights. Maybe there's certain encroachments. Like I said, people needing to actually walk through their land in order to gain access to maybe their own property or something on the land. Maybe, you know, I don't know, a telephone pole or something like that. So it just really depends. And again, not really much for you to do as a TC. It's more for the title company. They will handle all of those things. Now, if you do see a lien, a mechanic's lien, that is where you step in, because you can work directly with the seller to kind of speed up the process. Hey, this lien came up for mechanic's lien. Let's say it was they redid their kitchen and they didn't pay the loan. Maybe they did. Maybe they did. Just because there's a lien doesn't mean that it's not paid. It just means that the lien wasn't released. So that's where you would reach out to the seller, talk to them about it, and say, hey, was this paid for? Do you have a receipt? You have a receipt? Great. Please provide it to me so that I can provide it to the title company. If it was not, now the buyer and the seller need to talk about that, because if that was not disclosed before, they may need to do some renegotiations. And then disclosures. Schedule D outlines all parties who will receive any part of the premiums paid for the title policy, including title agencies, underwriters, and attorneys. Nothing for you to worry about here. This is something that between the title company and the title insurance company, they have, you know, the way that they split the funds up on how those premiums are paid, that'll be listed there. That has nothing to do with you. So now we're going to look at an example of a title commitment or title insurance. And I've redacted a lot of information here. The first 2 pages of the title commitment, you don't do anything with it. This is just standard language. It talks about the Alta commitment for title insurance, who it's issued by, who the company is. Fidelity is a big national title insurance company. Okay, you'll see and hear that name a lot. So you don't do anything with this. You're just going to scroll on by. You're going to scroll on by the first, actually 4 pages. We get to the 5th page, and this is the actual title commitment. So at the top, I've blacked out the information of the title company or the insurance company. I just blacked it out. This is Schedule A. The date of the title commitment is October the 15th. That's when they have prepared this. The policy to be issued is going to have your buyer's name, the amount of the policy, which it's always going to be the amount that they're purchasing the property for. Typically, it'll say it there. The estate or interest insured, so how they're going to take on ownership. Fee simple is typically what you'll see. And then we scroll down here, and number 4, we will see that the title commitment is vested in, or sorry, not the title commitment. The current title is vested in this. You'll see the seller's name. Okay. Who currently owns the property will be listed here. Number 5, the land is described as follows. See Exhibit A. So we scroll down. Here's Exhibit A. I've blocked some of the information. Okay. This is the legal description. The legal description is going to tell you south 33 feet, north this, block that. Like, it's a short paragraph describing where the land is located, where the property is located. You know, it's the legal description because it's, like I said, it's a little paragraph. It includes numbers. It includes the exact location of the property. Permanent index number, or APN. And down here is says no for the informational purposes only, commonly known as, here's the actual written out property address. So we scroll down. So Schedule B. Schedule B is the requirements. All of the following requirements must be met. And it'll tell you exactly here what needs to be met in order to get the clear to close. So it talks about, this is standard language here, guys. This is always standard language. It talks about the buyer paying the title insurance premium at closing. You know, just all of those things. Like here, number 6, it says the good funds section of the Title Insurance Act, effective January 1st, 2010. This act places limitations upon the ability to accept certain types of deposits into escrow. Please contact your local title company regarding this, blah, blah, blah. We don't do anything with that. How are funds sent into escrow? They accept wire. It's done electronically. They don't take cash. Title companies do not take cash. Even attorneys. No one is going to, like, at the closing table, they're not going to accept a lump sum of $100 grand in cash. It's just not going to happen. So it's either cash. I'm sorry. It's either wire or cashier's check, typically. And I believe those are really the only options. If there's anything else, maybe something different, but I don't know. It's always been the same for the amount of time that I've been doing this. Okay. So again, here, we don't really do much. This is really just standard stuff that just the title company handles. Additional requirements. So this is where we start seeing things about taxes. So number 1, general taxes for the year of 2024, 25, and subsequent years. The first estimated installment of 2024 taxes of $3,463.47 are paid. Great. She's up to date with taxes. Note, taxes for the year 2025 are not yet due or payable. Number 2, the following instrument may be defective for the reasons stated herein. And it tells you right here. This was a recorded, and this is what I mean, guys, that even title companies make mistakes. Attorneys make mistakes. Here, the deed was recorded in 2024. However, here's the defect. The legal description was missing the lot number. The lot number. When you're recording a deed, it needs to have all of the information, the exact information of the property. If anything is missing, it is now considered defective. Now, what happens? It's not the end of the world. It'll just get taken care of years down the road when the property gets sold, right? That's where they'll realize, like, hey, this was missed. No problem. We'll make a new deed, record it, right? So they will recreate that deed, re-record it, and then do the new deed for the new transaction and get it closed. That's all. But these are things that happen. Number 3, it tells us that the seller has a mortgage. And here's the nominee, neighborhood loans, blah, 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 in the amount of $520,400. It was dated on August the 23rd, 2024, and it was recorded September the 4th, 2024. Now you see that the date of the loan and the date that it was recorded are 2 separate dates. I want you guys to understand that every state and county, their recording time is different. Why is this important? The recording time, right? It is official. It is officially on record once it becomes recorded, right? Once the county receives it and it gives a recording number, this deed has been recorded, this mortgage deed has been recorded, and here's the date that it was, and here's the instrument number. So it may not be the same day. There may be a lag. Some counties are much, much longer than others. So when someone does a title, let's say someone was to do a title search on August the 25th, and their title search was quick, 24-hour title search. It may not show up that this seller took out a mortgage and that there is a first lien position. Okay? That's some dangerous information there. So the reason why it's not going to show is because it didn't get recorded until after the fact. And that can be concerning for some people, right? Because when you're doing title search, it's extremely important to know, what liens have been placed against the property. This is why title companies will have the seller sign an additional affidavit saying, hey, since we've been under contract or since we've been in escrow, I am confirming that I have not put any other liens against the property. And that document is oftentimes signed and notarized. Okay. Number 5, we should be furnished with the following. So this has to do with like their LLC documents or articles of incorporation, any amendments that go along with the operating agreement, and so on and so forth. You should be collecting this on the front end once you get the signed contract. This language may very likely still be there because it is just standard. That is something that they will always need. If your buyer does not have an LLC, like in this instance, there was no LLC, then that doesn't apply. Mind you, it was still there, but they didn't have an LLC. So there's nothing to do there. Number 7, and I'm skipping around at certain things because certain things it's just standard language and it doesn't really apply. And then other things are very specific to maybe the seller or the property itself. Number 7, by Chicago municipal ordinance, a transfer tax has been imposed upon the buyer for real estate located in the city. Therefore, all deeds presented to this company for recording must have the appropriate transfer tax affixed thereto. So this is just talking about transfer taxes. Anytime a deed changes hands, right? Let's say today I own the property, Jennifer Cortez. Next year I sell my property and now it's Joe Smo, right? Now that I've sold the property, there's going to be a transfer tax. Now, I said that was a year from now. But what if I own the property today and 6 months from now I go and sell it and Joe Schmo owns the house? There's still going to be transfer taxes, even though it happened in the same year. I don't care if it happened within the same month. Anytime a deed transfers from this person to that person, there will be transfer taxes. And that's, my friends, sometimes it surprises some buyers because some states, the transfer taxes are much, much higher than other states. Like Florida, very expensive. Very expensive. All right, moving on. So number 8, it talks about zoning, the zoning compliance. So it says the City of Chicago Zoning Department for residential property being sold or transferred must be obtained prior to closing and must appear in the City of Chicago transfer declaration form before any deeds are accepted or recorded or for recording or filing. This is just talking about something that the title company needs to do. They need to obtain a certification for zoning compliance. Zoning is important. We're going to talk very briefly about this. If a property is zoned for residential, it can only be used for residential unless they end up going through the process of trying to get it zoned to commercial. What do I mean by that? Let's say you see a house and you're like, ooh, I would love to run my business out of that house. You can't just do that. You can't just put a beauty salon in a house and now it's commercial. Do people do it? Yes. But if somebody finds out, they can actually report it to the Department of Zoning and they will face fines. So if it's zoned for commercial, then you cannot live there. It is zoned for commercial. If it's zoned for mixed use, it can be used for either or. That's why in certain locations, you'll see a house and they're using it as a real estate office. Maybe that house is actually zoned for mixed use or just commercial. It just depends, right? And so no one knows unless they contact the zoning department, and the title company would be in charge of doing that. And then on page 11 down here, it talks about the 24 month chain of title. So it tells us in the last 24 months, this is the chain of title. This person owned it, then they sold it to this person. In this case, there was only 2. There was the current owner and the owner prior to that, to her. That's it. You may have instances where they have an even longer chain of title. And let's scroll down. And that is it, guys. That is it for a title search or title commitment. I actually want to, there was a section, yes, we went over the mortgage already, so good. That is it for the title commitment or title search. It's a lot of information. It is a lot of information, but if you just take the moment to understand the different sections, the different schedules, then you'll realize that it's pretty easy. And you always want to lean on the title search or the title company if there is something that is not clear. You don't want to take this and make your own assumptions. We have clear title because that's what I read. I always put it on the title company. Please confirm that we have clear, marketable title. Is the title fully clear? Is there anything that we need to worry about? I still read it, and if I do see something, I will question it. That is the role of a transaction coordinator. I hope this was extremely helpful for you guys. In the course, in the cash course, you will receive a copy of the ABCs of a title commitment, and that will also include this example that we just went over into your resources as well. If you have any questions, you guys know where to find me. Talk to you soon.